A SAR is a report made under POCA 2002. It can be an internal SAR to our nominated officer, or an external SAR to the National Crime Agency, NCA. Internal SARs are made by you to our nominated officer. External ones are made by the nominated officer, usually following an internal SAR, to the NCA. There is a set format to a SAR. You can find our internal SAR form Appendix A of the Anti-Money Laundering and Counter-Terrorist Financing Policy. We will have a defense to a principal money laundering offense if we make a SAR to the NCA and receive appropriate consent, although the NCA calls it a defense to do the prohibited act. All three offenses require knowledge of the identity of the launderer or the whereabouts of the criminal property, or a belief that the information on which the suspicion is based may help to identify the launderer or the whereabouts of criminal property. Knowledge under POCA 2002 means actual knowledge rather than willfully shutting one's eyes to the truth. Suspicion is a possibility which is more than fanciful. A vague feeling of unease will not be sufficient. There is no requirement for the suspicion to be clear or firmly grounded on specific facts, but there must be a belief which is beyond mere speculation. The test for whether you hold a suspicion is generally subjective. However, there is an objective element to the test, i.e. would the reasonable solicitor, with the same knowledge, experience and information, have formed a suspicion. The suspicion held must be that another person is engaged in money laundering and not simply that there is something fishy about the client or the transaction. The Terrorism Act 2000, TA 2000, also contains a duty to disclose information where you know or suspect that another person has committed or is about to commit a principal terrorist property offense. It is an offense to fail to disclose any such knowledge or suspicion. We have a strict duty to keep the affairs of our clients confidential. The circumstances in which you can disclose information about our clients are very limited. However, POCA 2002 and the TA 2000 impose obligations to report knowledge or suspicion of money laundering or terrorist financing by way of a SAR. These obligations can override your duty of confidentiality. You should always report knowledge or suspicions and as soon as reasonably practicable. You will be required to explain any delays to the nominated officer. Remember, a report to the nominated officer is the only way to ensure your position is protected if your suspicions turn out to be correct under POCA 2002. If you know or suspect that another person is engaged in money laundering or terrorist financing, you must complete an internal SAR form, which can be found at Appendix A of the Anti-Money Laundering and Counter-Terrorist Financing Policy, and send it to the MLRO. In their absence, SAR forms must be sent to the COFA. Any member of staff can submit a SAR form to or discuss their concerns with the nominated officer. Our internal suspicious activity report form is intended to make the process of submitting SARs to the nominated officer as easy as possible. It is not intended to be time-consuming and should not be a daunting process. If you require consent to continue with the matter, then you must indicate this by using the relevant box on the SAR form or making it otherwise clear to the nominated officer. You will only receive consent to the extent that you ask for it, so remember to include every step that you will need to take to complete the matter on the SAR form. Do not keep a copy of the SAR form on the client or matter file. If you are unsure whether you suspect money laundering or terrorist financing, or proliferation financing, for example, something just doesn't feel right with the matter, do not complete the SAR form, but discuss your concerns with the nominated officer, who will advise whether you need to submit a SAR form. We will keep a note of that discussion. Please note, reporting a material discrepancy in relation to beneficial ownership information to Companies House is not the same as submitting a SAR. If you suspect money laundering or terrorist financing in a situation where you have submitted or plan to submit a discrepancy report form, you must also submit a SAR. We will discuss material discrepancy reports in more detail shortly. There is nothing wrong with discussing a potential report with a partner or head of department rather than the nominated officer in the first instance. It may be that they have a better insight into the client or the matter. However, if you still have suspicions, you should still speak with the nominated officer. Remember, a formal suspicious activity report, in whatever format, to the nominated officer is required where you decide you have suspicions. Privilege and other exemptions. Privilege may be a defense to a failure to report offense. It is a hugely complex area of law. Other narrowly drawn exemptions may apply. You should make a SAR to the nominated officer even where you believe privilege or another exemption may apply. It is for the nominated officer to decide whether privilege or another exemption applies and ultimately whether a SAR needs to be made to the NCA. On receiving your SAR form, the MLRO will consider the reasons for suspicion reported. They may ask you for more information. The MLRO will then decide whether an external SAR to the NCA is required. This decision rests only with the MLRO, or the deputy in case of absence. You have discharged your reporting obligations under POCA 2002 and the TA 2000 by making the internal SAR. If you need consent or a defense to continue acting for the client where to do so will involve your committing a principal offense, you must indicate this on the SAR form. The MLRO will refer to the NCA for its consent the defense. External SARs. If the MLRO make an external SAR, the NCA has 7 working days following receipt of the SAR to decide whether or not to give consent. If within this period, the NCA gives consent, or does not refuse consent, which means that, strictly, you will be deemed to have consent, but please refer to the MLRO who will provide guidance on what this means and the steps you cannot take. If the NCA refuses consent within 7 working days of receiving the SAR, it has a further 31 days to take action. This is called the moratorium period. In exceptional circumstances, the NCA may apply to the court to extend the moratorium period for a further period of 31 days and to keep making further applications up to a maximum of 186 days over the original 31 days. Implications for your work. You must follow the MLRO's instructions carefully during this period. You may work on the matter in the meantime, but must not transfer funds, take an irrevocable step in the matter, e.g. sign contracts or complete a deal, or do anything that constitutes tipping off. You can take steps which do not amount to committing a principal offense such as writing letters or conducting searches, etc. What you can tell the client after a SAR has been submitted is very limited. You must not tell the client that you have submitted a SAR. If you do, you will be committing the offense of tipping off and could be exposed to a criminal record and up to 5 years imprisonment. There is very little, if anything, that you can tell the client after you have submitted a SAR. Always speak with the MLRO if you are in any doubt. Please be aware that the MLRO is not able to seek status updates from the NCA for a consent request unless there is a life-threatening situation, or there is potential for significant harm. Super SARs are SARs compiled by more than one regulated organization which are then submitted jointly to the NCA. They are designed to reduce the number of SARs the NCA receives by allowing private sector entities to share information about suspected money laundering or terrorist financing before providing this information to the NCA in a single SAR. If you receive a request or notification from the NCA or another regulated organization relating to a Super SAR, you must inform the MLRO immediately. Now we will take a look at client due diligence and our policies and procedures in relation to it. Client due diligence is usually referred to as CDD. There are 3 basic components of CDD. It involves identifying and verifying the client's identity, identifying the beneficial owner where this isn't the client, obtaining details of the purpose and intended nature of the business relationship or transaction, and we are also required to conduct ongoing monitoring of business relationships with our clients. In terms of when, or the circumstances that trigger CDD, we must conduct CDD measures. When we establish a business relationship with a client. When we carry out an occasional transaction for a client. Where you suspect money laundering or terrorist financing. When you doubt the veracity or adequacy of documents or information previously obtained for the purposes of identification or verification. In relation to existing clients, we'll look at that a bit more on the next slide. We'll talk about timing of CDD in just a moment. In general, the client will be the party or parties with whom we are establishing a business relationship or for whom the transaction is carried out. Things can become more complicated with beneficial owners or where someone is acting on behalf of the client. We'll look at those issues in more detail later on. We cannot simply conduct CDD measures at the outset of a business relationship or transaction and then just forget about it. You must apply CDD measures at appropriate times to existing clients on a risk-sensitive basis, and if you become aware that the circumstances of an existing client have changed in a way that is relevant to your assessment of risk for that client. In determining when it's appropriate to conduct CDD on existing clients, we must take into account, among other things, any indication that the identity of the client, or its beneficial owner, has changed. Any transactions which are not reasonably consistent with your knowledge of the client. Any change in the purpose or intended nature of your relationship with the client, and a gap in retainers of 1 year or more. A client instructing on a higher risk matter or an existing high-risk client. Any legal duty you have in the course of the calendar year to contact an existing client for the purpose of reviewing any information which is relevant to your risk assessment for that client, and relates to the beneficial ownership of the client, including information which enables you to understand the ownership or control structure of a legal person, trust, foundation or similar arrangement who is the beneficial owner of the client. To fulfill any duty under the International Tax Compliance Regulations 2015. Any other matter which might affect your assessment of the money laundering or terrorist financing risk in relation to that client. If you are in any doubt, please contact the MLCO. So I've talked about when we must apply CDD measures, the things that trigger CDD, e.g. when we establish a business relationship with a client, if we suspect money laundering, etc. In terms of timing, we'll usually conduct our CDD measures right at the start, when the potential client first gets in touch. This is ideal, as life can get complicated if we make a start on a matter and then we're not able to apply CDD adequately. I'll talk you through that situation a little later on. But it's not always possible. The MLR 2017 contains requirements on timing of CDD which depend on the nature of the client relationship itself. You'll see on the slide that for occasional transactions, we must complete CDD before we carry out the occasional transaction, whereas for business relationships, we must complete CDD before we establish a business relationship or as soon as possible after initial contact during the establishment of the relationship where this is necessary so as not to interrupt the normal conduct of business, and there is little risk of money laundering. In either case, CDD must be completed before we deliver substantive work or benefit, permit funds into our client account, unless they are for fees and disbursements, allow property to be transferred, or allow final agreements to be signed and completed. You must seek guidance from the MLCO if there is any delay in the CDD process. They will advise you on steps to take and, where necessary, consider whether any delay in completing the CDD process is in itself grounds to suspect money laundering or terrorist financing. Let's move on to look at the different levels of CDD. There are 3 levels of client due diligence. Simplified due diligence, SDD. Enhanced due diligence, EDD. Regular due diligence, RDD. All levels of CDD require us to identify and verify our client, but each level has different identification and verification requirements and involves different documentation. We'll come back to this in a moment. CDD also requires us to identify and validate the identity of beneficial owners of a client. Simplified due diligence is not an exemption from CDD, it is simply a downwards adjustment of the level of measures we take to comply with CDD requirements. The information we obtain when applying SDD measures must enable us to be reasonably satisfied that the risk associated with the relationship is low and be sufficient to give us enough information about the nature of the business relationship to identify any unusual or suspicious transactions. Our approach to SDD is set out in our anti-money laundering and counter-terrorist financing policy. We can apply SDD in relation to particular business relationships or transactions which we determine present a low risk of money laundering or terrorist financing, having taken into account our firm-wide risk assessment, relevant information provided by our supervisory authority, and specified risk factors set out in the MLR 2017. These are incorporated into our client and matter inception procedures. SDD is also not an exemption from reporting suspicious activity to the nominated officer. Bear in mind that the presence of one or more risk factors may not always indicate that there is a low risk of money laundering or terrorist financing in a particular situation, but it is important that we consider all these risk factors for every client. Enhanced due diligence is a higher level of CDD, required to mitigate the increased risk presented by certain clients and certain situations. This involves taking additional steps to understand the ownership and control of the client and, in some cases, the source of funds involved in the matter. There is also a greater focus on ongoing monitoring, and you must have senior management sign-off to take instructions in some situation, which we'll talk about in a bit more detail later. We must apply EDD measures and ongoing monitoring. In any case identified as presenting a high risk of money laundering or terrorist financing, or proliferation financing, in our firm-wide risk assessment or by our supervisory authority. In any transaction or business relationship with a person established in a high-risk third country, where the client to potential client is a politically exposed person PEP, or a family member or known close associate of a PEP, we will go into more detail about this shortly. Where a client has provided false or stolen identification documentation or information for CDD purposes and we decide we still want to act. For non-face-to-face business relationships transactions. In any case where a transaction is complex or unusually large, there is an unusual pattern of transactions, or the transaction or transactions have no apparent economic or legal purpose. In any other case which by its nature can present a higher risk of money laundering or terrorist financing, taking into account various specified risk factors set out in the MLR 2017, e.g. matters favoring anonymity. For matters favoring anonymity. In any other case which by its nature can present a higher risk of money laundering, terrorist financing or proliferation financing, taking into account various specified risk factors set out in the MLR 2017. You should bear in mind that the presence of one or more risk factors may not always indicate that there is a high risk of money laundering or terrorist financing or proliferation financing in a particular situation, but it is important that we consider all these risk factors for every client. Regular due diligence applies where simplified and enhanced due diligence do not. Details of what RDD looks like in practical terms, including the specific documentary evidence we require, can be found in our anti-money laundering and counter-terrorist financing policy. Moving on to our process for conducting CDD measures. CDD is a central pillar of the AML and CTF regime. CDD requirements underpin the MLR 2017. The component parts of CDD are identifying a client, verifying that identity on the basis of documents or information obtained from a reliable source which is independent of the client, and assessing, and where appropriate obtaining information on, the purpose and intended nature of the business relationship or transaction. We must determine the extent of our CDD measures on a risk-sensitive basis, depending on the type of client, business relationship and matter. We must also be able to demonstrate to our supervisory authority, the SRA, that the extent of our CDD measures are appropriate in view of the risks of money laundering and terrorist financing identified in our firm-wide risk assessment and as identified by our supervisory authority and made available to us. You must start by assessing the risk of money laundering or terrorist financing posed by the specific client and complete the CDD client and matter risk assessment form, which you can find Appendix H of our anti-money laundering and counter-terrorist financing policy. Once this is complete, you must decide what level of, in other words, simplified, enhanced or regular, is necessary in terms of the client itself. This slide here contains a flowchart illustrating the first part of our CDD process. Hopefully some of the contents look familiar. That's not where our process ends, because despite the term client due diligence, CDD doesn't just relate to the client itself. The MLR 2017 also require us to consider the risks associated with the business relationship, which is broader than just the client, including product, service, transaction or delivery channel risks, geographical risk factors, which may apply to the client or to the matter, transaction itself. We also consider the elevated risks attached to certain sectors, which have been identified by credible sources as giving rise to an increased risk of corruption, e.g., domestic and international public work contracts and construction, including post-conflict reconstruction. Businesses using new or unproven technology that might make them vulnerable to being used for criminal purposes. High-value goods businesses. Items of archaeological, historical, cultural and religious significance or of rare scientific value. This may be of particularly high risk in jurisdictions with exposure to terrorism or terrorist financing activities. Mining, including precious metals, diamonds or other gemstones, and trading of these materials. Arms manufacturing, supply, and the defense industry. Tobacco products. Gambling. Crypto asset wallet providers and exchanges. Unregulated charities, particularly those operating in higher risk jurisdictions. Money transfer businesses. Ivory and other items and materials related to protected species. Real estate and property development, and the oil and gas industry, with the exception of the buying and selling of fuel for domestic consumption or retail. Matter risk assessment is a key part of our anti-money laundering and counter-terrorist financing measures. It is an ongoing process. Information gathered in the course of acting for a client will inform the risk assessment process. Our new matter form requires you to consider the anti-money laundering and counter-terrorist financing risk of the matter at the outset of that matter by completing a CDD client and matter risk assessment form Appendix H of our anti-money laundering and counter-terrorist financing policy. If there is any change to the nature of the risk throughout the course of the matter, you must record that fact, as well as any actions taken as a result on the file information sheet and inform the MLCO as appropriate. Unless the criteria for CDD on existing clients applies, as discussed earlier, we do not conduct the full CDD process for each new matter we open for an existing client. It is therefore important to get as full a picture as possible when we take on a new client and decide on the correct level of CDD at the outset of our relationship with each new client. When an existing client instructs us on a new matter, we should look at the instructions we typically receive and the type of work we're doing for that client before applying CDD measures. If the type of work or instructions change, you will need to start again from the beginning and reassess the risk presented by the business relationship with that client. Our procedure is set out on the slide here. Exactly what documents need to be gathered and the CDD steps you need to take will depend on a number of factors, including the nature of the client, e.g. an individual or a business, where they are located, etc. These are set out in detail in our anti-money laundering and counter-terrorist financing policy and our CDD client and matter risk assessment form, which can be found at Appendix H of our anti-money laundering and counter-terrorist financing policy. It is your responsibility to check the accuracy and adequacy of the documents provided. If you are in any doubt, please contact the MLCO. Sometimes clients are unable to provide standard verification documents. In these circumstances, we will consider whether the inability to provide us with standard verification is consistent with the client's profile and circumstances, or whether it might make us suspicious that money laundering or terrorist financing is occurring. Where we decide that a client has a good reason for not meeting the standard verification requirements, we will consider accepting other forms of documentation from an appropriate person who knows the individual and can verify the client's identity. For example, a client in a care home, we can accept a letter from the manager, or for an elderly client a letter from their GP, etc. We must apply EDD measures and enhanced ongoing monitoring in any business relationship with a person established in a high-risk third country or in relation to any relevant transaction where either of the parties to the transaction is established in a high-risk third country. A high-risk third country means a country named on either of the following lists published by the Financial Action Task Force, FATF, as they have effect from time to time. High-risk jurisdictions subject to a call for action. Jurisdictions under increased monitoring. The requirement to apply EDD for high-risk third countries applies where there is a relevant transaction and establishment in a high-risk third country. A relevant transaction is a transaction in relation to which you are required to apply CDD measures under Regulation 27, MLR 2017, and being established in a country means. In the case of a legal person, being incorporated in or having its principal place of business in that country, or, in the case of a financial institution or a credit institution, having its principal regulatory authority in that country, and, in the case of an individual, being resident in that country, but not merely having been born in that country. You are not required to apply EDD where the client is a branch or majority-owned subsidiary undertaking of an entity which is established in a third country if all of the following conditions are satisfied. The entity is subject to the requirements in national legislation having an equivalent effect to those laid down in 4 MLD as an obliged entity, and supervised for compliance with those requirements. The branch or subsidiary complies fully with procedures and policies established for the group, and, having applied a risk-based approach, you do not consider that it is necessary to apply EDD measures. We maintain a list of high-risk third countries, which you can find, state location, e.g. on the intranet. Note that countries not specifically identified by the FATF are not automatically considered to have effective anti-money laundering and counter-terrorist financing systems. Other jurisdictions may equally pose higher money laundering risks. These should be assessed as part of your client and matter risk assessments, and additional EDD measures should be applied as appropriate. If in doubt, contact the MLCO. EDD measures for matters involving high-risk third countries must include obtaining additional information on the client and on the client's beneficial owner. Obtaining additional information on the intended nature of the business relationship. Obtaining information on the source of funds and source of wealth of the client and of the client's beneficial owner. Obtaining information on the reasons for the transactions. Obtaining the approval of senior management for establishing or continuing the business relationship. Conducting enhanced monitoring of the business relationship by increasing the number and timing of controls applied, and selecting patterns of transactions that need further examination. So what is a politically exposed person and why are they high risk? A PEP is an individual who is entrusted with prominent public functions, other than as a middle-ranking or more junior official. Individuals who have or have had a high political profile, or hold or have held public office, can pose a higher money laundering risk as their position may make them vulnerable to corruption. This risk also extends to members of their immediate families and to known close associates. PEP status itself does not, of course, incriminate individuals or entities, but it does put the client or the beneficial owner into a higher risk category. Establishing whether individuals qualify as PEPs is not always straightforward and can present difficulties. The Economic Crime and Corporate Transparency Act 2023, ECCTA 2023, introduced changes to the MLR 2017, relating to domestic and non-domestic PEPs, i.e. domestic PEP, a politically exposed person entrusted with prominent public functions by the UK. Non-domestic PEP, a politically exposed person who is not a domestic PEP. Domestic PEPs are still classed as PEPs and as yet no other requirements relating to PEPs in the MLR 2017, or any published guidance on those requirements, have changed. You are still required to identify all PEPs, but your starting point in terms of your risk assessment is different depending on whether a PEP is domestic or not. To determine whether a client or its beneficial owner is a PEP or a family member or known close associate of a PEP, and to manage the enhanced risks arising from our relationship with such a client, we set out your system procedure for identifying PEPs, e.g. using Legal or InfoTrack a simple PEP. Sanctions check directly via OFSI at https://sanctionsearcap.ofsi.hmtreasury.gov.uk. It is important that we all remain alert to situations suggesting the client is a PEP, e.g. receiving funds from a government account, correspondence on official letterhead paper from the client or a related person, information from the client or person related to the retainer linking the client to a PEP, Any information which comes to your attention suggesting your client is a PEP or is linked to one. Once we have established that a client is a PEP, we must apply EDD measures to that client. The EDD measures we take for PEPs depend on the level of risk associated with the particular client. Of course, all PEPs must be treated as high risk, but some will be higher risk than others. Relevant factors to consider include whether the PEP is domestic or non-domestic, the particular circumstances of the PEP, the prominent public function the PEP holds, which will vary according to the nature of the function held. Any other relevant factors we have considered in our risk assessment. The PEP's separate business interests and the time those interests prevailed in relation to the public position. Whether the PEP has access to official funds, makes decisions regarding the allocation of public funds or public procurement contracts. The PEP's home country. The type of activity about which the PEP is instructing you. The potential for our services to be misused for the purpose of corruption. Whether the PEP is domestic or international, particularly having regard to the services asked for. The scrutiny to which the PEP is under in the PEP's home country. The type of budgets usually associated with government agencies or officials from the particular jurisdiction. If money is coming from a government account, consider whether it is being used for purposes considered to be legitimate government spending. If they have close family members or known associates, and if so, consider the roles they hold. If you have identified a PEP, whether they were helpful in providing this information, and if not, should and how this impacts your assessment of the risk. Consideration of the level of public scrutiny, exposure, governance, disclosures or accountability to which the PEP is subject. If a PEP is otherwise involved with a client, then you should consider the nature of the risk in light of all relevant circumstances, e.g. the nature of the relationship between the client and the PEP. The nature of the client, e.g. where it is a public listed company or regulated entity which is subject to and regulated for anti-money laundering and counter-terrorist financing requirements, including being subject to reporting obligations, that will be a relevant factor. The nature of the services sought, e.g. lower risks may exist where a PEP is not the client but a director of a client that is a public listed company or regulated entity and the client is purchasing property for adequate consideration, whereas higher risks may exist where we are involved in the movement or transfer of funds, assets, or the purchase of high-value property or assets. For all PEP clients, we must have approval from senior management for establishing or continuing the business relationship with that person. Take adequate measures to establish the source of wealth and the source of funds which are involved in the proposed business relationship or transaction. We'll come back to source of funds, source of wealth in a short while, and conduct enhanced ongoing monitoring of the business relationship with that person. The slide contains some examples of further steps we may consider taking for PEPs, depending on the level of risk presented by the particular client. We must apply EDD where a transaction is complex or unusually large. There is an unusual pattern of transactions, or the transaction or transactions have no apparent economic or legal purpose. Whether a transaction is complex or unusually large should be judged in relation to the normal activity of both the firm and the client. EDD measures we must apply here include, as far as reasonably possible, examining the background and the purpose of the transaction, and increasing the degree and nature of monitoring of the business relationship to determine whether the transaction or relationship appear to be suspicious. Some of the matters we conduct could favor anonymity. These include, for example, those involving opaque trust or company structures, including those featuring, e.g. bearer shares, some offshore trusts, legal entities like foundations, etc. Overly complex matters, e.g. obscuring parties or source of funds. Transactions involving cash, electronic currency, or virtual assets. Where we act for clients, we do not meet face-to-face. Services where we act as trustees director that allows the client's identity to remain anonymous. Matters for clients who are celebrities and wish to remain anonymous. Clients that are evasive as to the identity of the parties involved. We apply EDD to matters which might favor anonymity, where appropriate. EDD involves doing more than we would for transactions or matters classed as standard risk. The specific measures we apply will depend on the reason the transaction or matter favors anonymity and will boil down to the assessment of the risk presented in the particular case, but will include the measures set out in the next section. Finally, let's look at that catch-all provision, EDD, for all other high-risk matters. We set out practical steps to take for other high-risk clients in our Appendix C of our anti-money laundering and counter-terrorist financing policy. These may include seeking additional independent, reliable sources to verify information provided by the client, taking additional measures to understand better the background, ownership, and financial situation of the client and other parties to the transaction, taking further steps to be satisfied that the matter is consistent with the purpose and intended nature of the business relationship, increasing the monitoring of the business relationship, including greater scrutiny of transactions. We will also consider increasing the quantity of information obtained for CDD purposes, e.g. information about the client's or beneficial owner's identity or the client's ownership and control structure, by obtaining and assessing information about the reputation of the client beneficial owners and assessing any negative allegations against them, information about family members and close business partners, information about the client or beneficial owner's past and present business activities, adverse media searches, and about the intended nature of the business relationship, e.g. on the likely size and frequency of current and future matters. Requesting evidence on why the client is looking to instruct you on a specific service, in particular where it is unclear why the client's needs cannot be met better in another way or in a different jurisdiction, and the destination of funds. Requiring the first payment to be carried out through an account verifiably in the client's name and with a bank subject to UK CDD standards. Taking more intrusive and exhaustive steps to establish the client's source of wealth and the source of funds to be used in the business relationship, ensuring they are, not the proceeds from criminal activity, and 2, consistent with the firm's knowledge of the client and the nature of the business relationship. Verifying the source of wealth and the source of funds, e.g. by reference to VAT and income tax returns, copies of audited accounts, pay slips, public deeds or independent and credible media reports. Increasing the frequency of reviews of the business relationship to ascertain whether the client's risk profile has changed and whether the risk remains manageable. Obtaining the approval of senior management to commence or continue the business relationship to ensure senior management are aware of the risk the firm is exposed to and can take an informed decision about the extent to which they are equipped to manage that risk. Where senior management approval is required, you must submit your new client form and/or new matter form to the MLCO for approval. Their signature constitutes confirmation that the client or matter can be accepted. See our new client and matter risk assessment form at Appendix H of our anti-money laundering and counter-terrorist financing policy. Moving on now to beneficial owners. CDD on beneficial owners is different to CDD on clients. Where the client is a legal person, trust, company, foundation or similar legal arrangement, you must take reasonable measures to understand the ownership and control structure of that client. When conducting CDD, we must consider whether the client is beneficially owned by another person. If so, we have 3 obligations. 1. Identify the beneficial owner, i.e. the natural persons who ultimately owns or controls the client and/or the person on whose behalf a transaction is being conducted. 2. Take reasonable measures to verify the identity of the beneficial owner so you are satisfied you know who the beneficial owner is, and 3. If the beneficial owner is a legal person, trust, company, foundation or similar legal arrangement, take reasonable measures to understand the ownership and control structure of that legal person, trust, company, foundation or similar legal arrangement. The MLR 2017 identifies 6 main categories of client that may have a beneficial owner. Corporate body, i.e. companies, and limited liability partnerships, LLPs, which is not a company whose securities are listed on a regulated market. Partnerships, trusts, Foundations or other legal arrangement similar to a trust. Estate of a deceased person in the course of administration. Other legal entity or legal arrangement. There is a catch-all provision for any other case. Note that a beneficial owner must be a human being, heart beating and blood pumping. If the beneficial owner of a client is a company, you will need to establish the human being at the top of that company, and so on until you find the beneficial owner at the top of the corporate tree. Who the beneficial owner of an organization is, and the steps we need to take to identify and verify the identity of them will depend on the nature of the organization itself. It's not always screamingly obvious. We've set out detailed information on beneficial ownership in our Guide to Beneficial Ownership for Law Firm Staff, which can be found at Appendix E to the Anti-Money Laundering and Counter-Terrorist Financing Policy. Before establishing a business relationship with a company, unregistered company LLP, eligible Scottish Partnership client, a trust client which is subject to registration under the MLR 2017, or an overseas entity which is subject to registration under the Economic Crime, Transparency and Enforcement Act 2022. You must collect proof of registration or an excerpt of the register from the client, or from the registrar in the case of an eligible Scottish partnership. The excerpt of the register must contain full details of the beneficial owners of the client, or in relation to an overseas entity, contain required information relating to registrable beneficial owners held on the register at the relevant time before the business relationship is established, or you must establish from your inspection of the register that there is no such information held on the register at that time, in which case, you must document this as part of your CDD record and/or client matter risk assessment. If you find any material discrepancy between the beneficial ownership information on the register and the information made available to you in the course of carrying out CDD or ongoing monitoring, you must report it. You must then consider the client's risk profile, the structure of the business and the nature of the transaction. This will help you to decide what steps you need to take to verify the beneficial owner's identity. In assessing the risk, you should consider why your client is acting on behalf of someone else. How well you know your client. The type of business structure and its location. The nature and risk profile of the matter. The key is to understand the ownership and control of the client. It is for you to determine a tailored and risk-sensitive approach that is appropriate to ensure you are satisfied you know who a beneficial owner is and that you fully understand their relationship with a non-natural person. You will need to assess which identity verification measures are needed, considering the client's risk profile, any business structures involved, and the proposed transaction. It is not enough to solely rely on the information contained in a company's register of persons with significant control. The level of verification required will depend on your assessment of your client's risk profile. Appropriate measures may include shareholder details from a reputable online registry or commercial provider, a copy of a detailed structured chart, and a copy of the trust deed, partnership agreement or other such document. There may be rare occasions where we are not able to identify the beneficial owner. If you are unable to identify the beneficial owners, you should inform the MLCO, who will tell you what further action is needed. The concept of beneficial ownership should not be confused with a situation where a client appoints someone to act on their behalf. Where a person, the representative, purports to act on behalf of the client, you must verify that the representative is authorized to act on the client's behalf. Identify the representative, and verify the identity of the representative on the basis of documents or information obtained from a reliable source which is independent of both the representative and the client. For the specific measures you must take, please refer to our Anti-Money Laundering and Counter-Terrorist Financing Policy. Before establishing a business relationship with a company, unregistered company LLP, eligible Scottish Partnership client, a trust client which is subject to registration under the MLR 2017, or an overseas entity which is subject to registration under the Economic Crime, Transparency and Enforcement Act 2022. You must collect proof of registration or an excerpt of the register from the client, or from the registrar in the case of an eligible Scottish partnership. The excerpt of the register must contain full details of the beneficial owners of the client, or in relation to an overseas entity, contain required information relating to registrable beneficial owners held on the register at the relevant time before the business relationship is established, or you must establish from your inspection of the register that there is no such information held on the register at that time, in which case, you must document this as part of your CDD record and/or client matter risk assessment. This can be found at Appendix H of our AML and CTF policy. We must also collect an excerpt of the register containing full details of beneficial ownership after a business relationship with a client has been established when taking measures to fulfill our duties in relation to ongoing monitoring of a business relationship, including enhanced due diligence, EDD, and enhanced ongoing monitoring, or must establish from our inspection of the register that there is no such information held on the register at that time, in which case, you must document this as part of your CDD record and/or client matter risk assessment. This can be found at Appendix H of our anti-money laundering and counter-terrorist financing policy. If we find a material discrepancy between the beneficial ownership information on the relevant register and the information made available to us by the client, or through ongoing monitoring, we must report it to the relevant registrar or commissioners, which must then take appropriate action to investigate it in a timely manner. Only discrepancies which are materials are reportable, so not typos or minor spelling mistakes. A material discrepancy is defined in the MLR 2017 as by its nature, and having regard to all the circumstances, a discrepancy which may reasonably be considered to be linked to money laundering or terrorist financing, or to conceal details of the business of the client. Discrepancies may relate to a difference in name, an incorrect entry for nature of control, an incorrect entry for date of birth, an incorrect entry for nationality, an incorrect entry for correspondence address, a missing entry for a person with significant control, PSC, or a registrable beneficial owner, an incorrect entry for the date the individual became a registrable person. It is not a discrepancy if we hold information that goes beyond or is of a different nature from that required for the register. We are not required to actively seek out discrepancies or report information which is subject to legal professional privilege. If you discover a discrepancy, you must complete our CDD Beneficial Ownership Discrepancy Report form and submit it to the MLCO, who will then review the information documentation and make a report to the relevant registrar. This can be found at Appendix I of our AML and CTF policy. Where you conclude that a discrepancy does not require a report to be made, you should document this as part of your CDD record and/or client matter risk assessment. This can be found at Appendix H of our AML and CTF policy. Let's move on to source of funds and source of wealth. Understanding the client's source of funds and source of wealth is an important step in the CDD process. They are both relevant to determining a client's risk profile. Source of funds and source of wealth are not the same, although there can be significant overlap between the two, and they do not exist in isolation to each other. Source of funds refers to the funds being used during the client's business relationship with you. Checking this means ascertaining where those funds came from, how they were accumulated by the client, and ensuring, using a risk-based approach, that they are not the proceeds of crime. The information obtained should be substantive and establish a provenance or reason for having been acquired. Source of wealth refers to the origin of the client's entire body of wealth, i.e. total assets. This information will usually give an indication as to the amount of wealth the client would be expected to have, and a picture of how they acquired their wealth. You are not required to interrogate all clients about their entire financial history, but there are specific circumstances in which we must obtain more information on source of funds and wealth. You must establish the source of funds involved in a transaction in relation to ongoing monitoring. You must establish the source of funds and source of wealth. When conducting CDD on PEPs, including family members and known close associates. When conducting CDD in relation to any business relationship with a person established in a high-risk third country, or any relevant transaction where either of the parties to the transaction is established in a high-risk third country. Where a third party is providing funding to your client. For more information on when you must establish the client's source of funds or source of wealth, see our Anti-Money Laundering and Counter-Terrorist Financing Policy and Appendix F. Scrutinizing the source of funds is more than asking for the money to come from a bank account in the client's name. It involves ascertaining where those funds came from, how they were accumulated by the client, and ensuring, on a risk-based approach, they are not the proceeds of crime. For source of wealth, you are not required to account for all the client's assets, but you must build a rationale and reasoning to explain why they have such wealth and provide assurance that it was obtained through legal means. This will help you to establish whether the transaction makes sense. For transactions involving PEPs in particular, you should consider whether there are any warning signs of corruption, or is any evidence that government or state funds are being used inappropriately. You must document your investigations into the source of funds wealth, including any questions asked, responses received, and supporting evidence provided. We do this through our source of funds wealth statement and our source of funds wealth investigation record. If you have any concerns about the source of funds or source of wealth, you must consider whether you need to submit a SAR to the MLCO. Understanding and, where appropriate, obtaining information on the purpose and intended nature of the business relationship is the final component of CDD. We record details of the purpose and intended nature of a client relationship on our new client and matter risk assessment form at Appendix H of our anti-money laundering and counter-terrorist financing policy. Knowing more about the client and their normal activities will help you to spot something unusual. Remember, a transaction that appears to serve no purpose could be a money laundering or terrorist financing or proliferation financing warning flag. Okay, so what happens if you can't conclude the CDD measures we've talked about today? Well, where we are unable to apply CDD measures, the general rule is that we must not carry out a transaction through a bank account with the client or on their behalf. Not establish a business relationship or carry out an occasional transaction with the client. Not accept or return funds from the client or on the client's behalf. Terminate any existing business relationship with the client and consider whether a SAR is required. There are very limited circumstances in which this may not apply. If you believe the client you are dealing with may fall within an exception to this rule, you should contact the MLCO. You must never unilaterally decide that it is acceptable to delay completion of CDD. If you are unable to apply or complete CDD on any matter, you should immediately seek advice from the MLCO. We do allow third parties to conduct CDD on our behalf. The MLR 2017 allow us to rely on a third party to apply any or all of the required CDD measures. However, they are very specific about exactly who we can and cannot rely on. We remain liable for any failure in the third party's application of those measures. We are required to obtain from the third party all the information needed to satisfy CDD requirements and enter into written arrangements with that third party which enable us to obtain copies of any relevant documents and require the third party to retain those documents. Because of the strict regulatory rules around reliance, you must not unilaterally decide to rely on CDD conducted by a third party or agree to another firm relying on us. You must contact the MLCO, who will decide whether we can rely on the third party or they can rely on us and, if so, will provide guidance on the procedure to be followed. We cannot be relied on by other firms to perform CDD measures on a mutual client. Offering or agreeing to confirm that we have carried out appropriate CDD measures in respect of a client is a serious matter. Any such requests from other firms must be forwarded immediately to the MLCO.